Welcome back. The Employment Equity Amendment Act of 2022 came into effect at the start of the month. The Act's focus is described as being all about promoting diversity and equality in the workplace. The amendment introduces some important changes, including a revised definition of the term designated employer and sector-specific employment equity targets set by the Minister of Employment and Labour. Now, to help us understand all of this and why the changes are significant, I am joined by Mandilakhe Gcilitshana, a Development and Employment Equity Specialist. Mandilakhe, a very good evening to you. Thank you so much for joining us. Now, just tell us about what these changes are that have come into effect this month, and also how significant they are.
Firstly, good evening, Masa, to yourself and your viewers at home. Masa, so the two main things with the changes that have been implemented as of the 1st of January, like you rightfully said, the first one is the amendment of the definition of what a designated employer is. Previously, before the 1st of January, these would be employers that, one, have more than 50 employees, and two, if they've got less than 50 employees, they need to meet a particular annual turnover threshold as per Schedule 4 of the Act. And then also if you're a state organ, municipality, or you're bound by a collective agreement. Now, as of the 1st of January, the threshold of your revenue has since been removed, meaning then that small organizations that have got less than 50 employees and had been complying only because of the annual turnover threshold are no longer required to comply with Chapter 3 of the Employment Equity Act. Remember, you've got Chapter 1 and Chapter 2 of the Act that applies to all employers, particularly Section 6 of the Act that prohibits unfair discrimination in the workplace. That section of the Act still applies to these small employers. What is no longer applicable to them is for them to carry on with the duties of the designated employer, which includes working towards having equitable representation. And if you're looking at the argument that the department is making, it actually makes sense to a large extent that these small employers have taken on a burden of trying to be equitable have an equitable representation in their workplace, whereas they're already small in size. Take, for instance, a big organization, they would probably have, to more than 5 people in senior top management. But the smaller guys don't necessarily have that. They would probably have 1 or 2 employees. And the issue now is that they aren't able to have that equitable representation because you can't have more than, 2 demographics in terms of race and gender in that particular level, because that's the number of employees that they have, let's say, in senior management, and argument's sake. Then the second one is the other one that we mentioned, is that they have made the rules to be a little bit stricter. In fact, a little bit different now with the EAP for the designated employers, where they're saying the EAP needs to speak to each industry. So those are the two main changes that the department is actually implementing.
When it comes to employment and equity in South Africa as well, the question of redress and economic empowerment, particularly for the previously disadvantaged and marginalized Black people, colored and Indian people, that is a major theme when it comes to employment. What does this change mean for those companies with less than 50 employees? Does that mean that they don't necessarily have to abide by such?
All right. So as I was saying earlier on, that the element of the Act where you are not allowed to discriminate unfairly against any person, if you go to Section 6, it then lists the grounds, including the items you've mentioned, race, gender, and other items. So those small employers, they cannot now say, because we are no longer designated, we can therefore appoint anyone, even if it means that we're going to unfairly discriminate against people. Yes, the criterion of a suitable qualified person will still be applicable, and also they still need to be sensitive to the people that were previously disadvantaged. The only difference is that now they won't be forced to align themselves with the economically active population, which in essence will tell you that in your organization, you should be having a certain percentage of African, colored, Indian people and white people as well, either for males or females. So the difference now is that they won't be forced to have those type of plans that they have to put in place to try and address redress the imbalances of the past. However, they still have an obligation to make sure that in their workplace, they take away any policies that in themselves are unfairly discriminating. As a result, if they are unfairly discriminating against anyone, as per Section 6 of the Act, the relevant, employees or employers organization or employee organizations, they can still take that employer. In fact, anyone can still take that employer to the CCMA or the labor court to institute a fine against them that will be suitable, because they will be still contravening the Employment Equity Act and also the Constitution as well. So the idea behind transformation is not being taken away from necessarily from these employers. However, the idea is that they must then lessen the burden of trying to achieve the EAP targets that for them has proven to be a little bit difficult to achieve compared to your bigger organizations.
So it will give them a little bit of less of a headache, less red tape as well, I guess, as well. So how have these businesses reacted? Those who do employ less than 50, I'm sure have welcomed it, but those who employ more than 50, Mandilakhe, how have business in general reacted to this?
Look, Masa, you would have, different, different reactions from different organizations. There is, though, a huge welcome for those small organizations, because they understand now that they can now go and actually contribute in stimulating the economy without, this burden of trying to align themselves with the EAP. Whatever that they see fit that is in alignment with the Employment Equity Act, as I've said numerous times, Section 6 of the Act, they can still implement that. But the idea now is that they don't now need to go and implement your plan and have your affirmative action measures. The big organizations, they are relieved as well to some extent, because the EAP targets that now they'll be facing will be sectoral EAP targets, not the ones that we previously had, where there was a combination of the different industries. For example, you would find your wholesale and retail industry trying to chase targets of 42% of African males, when probably almost 45% to 48% of males in general. But when you're looking at the actual industry, it is dominated by females. Now, with the new EAPs that the department is currently consulting on, they will change that and make sure that each industry, the EAP that they need to attain, will then be applicable to their specific industry. So there is a little bit of a relief from those industries as well. However, you will still have a few individuals who would like to see transformative law being scrapped off and not being implemented. But as we can see, that the department is not yet ready to do that, because they can see the role that it is still required that there are such laws to help to assist with the transformation that the country actually needs.
And while there is some relief, there still needs to be compliance as well with these new amendments. What are the potential penalties of non-compliance for specifically like these smaller businesses as well? And how can they then go ahead and mitigate against these risks of not complying?
Yeah. So fortunately for the small organizations, the duties of the designated employer as per Section 13 of the Act will no longer be applicable to them, meaning that the penalties that you would find under Schedule 1 of the Act will no longer be applicable, because they won't be in a position to contravene anything that is listed there. However, if they still do contravene Section 6 of the Act, they can still be found wanting in terms of not complying with having an organization that is not discriminating unfairly against employees. Then based on that, they can still then find themselves, being in a position where they can be fined. The difference now is that whatever penalty that they will face is not fixed as per the other employers that need to comply with Chapter 3 of the Act. What they can do, number one, is to make sure that they are compliant with Chapter 6 of the Act. And basically, there are just main three things that they need to pay attention to. One, make sure that their policies, directly or indirectly, are not discriminating against any person in their workplace. And those would be the listed grounds like race, gender, religion, and other items that are listed there, including arbitrary grounds. Secondly, make sure that there are no sexual harassment or harassment concerns in their workplace, because harassment of any form is considered to be unfair discrimination as per Section 6 of the Act. And then lastly, that they don't contravene the minimum wage as well, because that is something the department is also looking into, because potentially there is an observation that people from different demographics may be paid differently, either based on race or based on gender. So those things they need to pay attention to, that if people are doing work of or more or less the same value, they need to be compensated more or less the same. If not, then there should be a reasonable justification. What then the small organization can do further now is that since the 1st of January, they are no longer required. However, at the moment, there's no indication from the department of how do they get themselves off the list or the register that is with the Department of Labor. So the advice that we are giving employers strategy is that they must submit the EA14 form so that they can be removed from the list so that they are no longer compliant.
Mandilakhe, thank you so much for helping us understand all of this and clarifying and giving those tips as well. Really appreciate your time. That is an employment equity specialist, Mandilakhe Gcilitshana.